Tribunal can de-seat the candidate on the basis that prior to election you were disqualified.
That is my second argument when I'll distinguish between Article 62 and Article 63.
My question is whether under 62, whether somebody can be disqualified. Or 62 says if somebody is earlier disqualified, so his paper should be rejected.
He has to be earlier qualified on the date of the nomination paper.
So 62 does not clearly say that the person who is scrutinizing the documents has the power to disqualify somebody.
The date is the nomination date.
We've understood that point.
My lord.
If I can just re-articulate my colleague's question. This 68, I've just run through it.
My lord.
It talks about disqualification.
My lord.
The nomination paper aapne diya, I'm the returning officer or the election commission or the election tribunal. I say you're disqualified for you're 24 years of age, for instance. You can't contest election. You are a bankrupt. You can't contest election. You have not paid your bijli ka bill. You have not contested. You're not a graduate, etc., etc., etc. This paper gets rejected. Where is the power of the commission or the tribunal to say that you're disqualified for life? The next election comes along. You are disqualified in this election. You again present your paper. I again look at your papers. And again, I find, no, you are not qualified for these reasons. How an earlier disqualification, suppose now I'm 25 years of age, suppose I filed 24, naturally I can't contest elections. Or I'm a bankrupt, now I'm not a bankrupt, or I'm a loan defaulter, I've repaid entire loan, or I've not paid my electricity bill, I've repaid everything. So that will not travel through. Where is section 68 say that once disqualified, you're disqualified for life? Where is that provision?
My lord,
that provision has only been inserted by Samiullah Baloch.
that's what I'm saying, that for the time being, I am just arguing on one point, that is who can give the declaration of
I
disqualification.
agree with you.
First,
there is no dispute
the
on
second
that.
thing is to answer my lord's question, I have to create a distinction between 62 and 63. That is my second submission.
No, first of all, where is the power in the court, in this court to do this? That is the essential question.
Court has to determine whether he was qualified on the day of nomination under 62, 63.
वो रिजेक्ट कर देना उसे, और अगर उसने गलत बयानी से किया उसको रिजेक्ट कर दे. पर नेक्स्ट इलेक्शन जब आ रहा है तो हाउ इज ही स्टिल डिस्क्वालिफाइड, ये बताए ना सिर्फ पॉइंट.
Now I will come to answer this question. I will come to my second.
देखिए, एक आदमी ने एक रोपा में चेंज हुआ कि जी ग्रेजुएट होना चाहिए. एक ग्रेजुएट नहीं, उसने दरखास्त फाइल कर दी, वो मेट्रिकुलेट है. नेचुरली ही विल बी डिस्क्वालिफाइड. अगले इलेक्शन में ये कंडीशन है ही नहीं, तो ही कांट बी अ लाइफ टाइम बार. इट्स इलॉजिकल.
That's what I'm saying. Article 62 may, if there is a declaration that person is not honest. Why he was not honest? Because in my case.
Now you've taken a leap of faith.
No, my lord.
No. लेकिन अब आ जाती बात ये leap of faith वाली. So you are saying honest. Now honest. Suppose okay, let's take another case. Make it simple. He honestly declares in his nomination papers that he's a matriculate. He honestly declares in his paper that he's 16 years of age. Honestly, उसने लिखा 16 साल का हूँ. Consequence तो वही होगा ना.
My lord, if he is not 16 years of age.
भाई वो कह रहा है मैं हूँ 16 साल का.
If he is not 16 years of age and he is 14 years of age.
आप बात नहीं समझ रहे हैं ना. 25 साल का सिर्फ लड़ सकता है ना इलेक्शन. वो सचमुच कहता है मैं 16 साल का हूँ. वो सचमुच कहता है मैं ग्रेजुएट ना हूँ. आप इसको नेचुरली कांट कंटेस्ट इलेक्शन. सो ये जो ऑनेस्टी और डिसऑनेस्टी वाली बात तो बिकम्स इररेलेवेंट. इट्स अ फैक्चुअल डिटर्मिनेशन.
That's what I'm saying. Fact. Who has to do the factual determination?
चले ओके आगे बढ़े. मैं
Only election tribunal through recording of evidence.
We've understood the first point, please.
Now my
Move on
second
to the
point.
next point, please. The duration part.
इसी पे देखे ना, जो फर्स्ट आपने कहा कि प्री इलेक्शन जो उसकी नॉमिनेशन पेपर की रिजेक्शन है, that does not cover the grounds mentioned in 68. वो तो होने ही after the election है.
After the election.
तो इसलिए वो
तो just rejection of the papers.
that's
As per your arguments.
That is my
उसमें कोई declaration, कोई further
What is
नहीं होती.
वो क्वालिफाइड था या नहीं था पहली डेट के ऊपर, वो तो रिटर्निंग ऑफिसर ने चेक करना है ना. अगर रिजेक्ट होगा तो अपील हो जाएगी, अगर कोई अपोज करेगा तो भी अपील हो जाएगी. ठीक है ना. मगर बात क्वेश्चन इज दिस कि आफ्टर सेवरल इयर्स वो कहेंगे इवन एट द टाइम ऑफ फाइलिंग योर नॉमिनेशन पेपर यू वर डिस्क्वालिफाइड. दैट डिक्लेरेशन इज टू बी गिवन बाय विच कोर्ट?
Election tribunal.
इलेक्शन ट्रिब्यूनल.
You understood that, Mr. Khurram?
चलो अब एक
Now I will
Khurram,
do-
let's proceed further. You-
एक बात इसमें और बता दें. इलेक्शन ट्राइब्यूनल क्या डिस्क्वालिफिकेशन 60 आर्टिकल 63 से हट कर दे सकती है? और अगर कोई डिक्लेरेशन वो कर दे कि इज डिस्क्वालिफाइड और वो डिस्क्वालिफिकेशन 63 में नहीं आता,
नहीं दे
क्या उसके बुनियाद पर
नहीं दे
फॉर इवन फॉर सिंगल डे ही कैन बी बार्ड फ्रॉम कंटेस्टिंग?
Election tribunal has to decide on the basis of 62 for qualification.
No,
and 63.
disqualification is 63. This is clear. If any declaration is made by the tribunal,
My lord.
which is not in accordance with Article 63, whether on that basis, even on the declaration of tribunal, somebody can be debarred from life or even for a day.
No, my lord. Without trial cannot.
Even trial is conducted, the tribunal come to the
Even after trial, it
वो
cannot.
वो कह देता है कि disqualified.
Without the ground given in 63, he cannot.
Mr. Khurram, could we just summarize what's happened? Your submission is that, first of all, disqualification can only come through a plenary, court of plenary jurisdiction, plus the election tribunal and the appellate forum hearing that election tribunal's appeal. That's one. And declaration cannot come from any other
Small
source.
change here. No,
मैं कुछ और कहना चाहता
My
हूँ.
lord.
So this we've understood. I'm just saying that the premises on which Samuel Baloch proceeds is that once that declaration is in the field, that you're disqualified.
My lord.
Unless that declaration is set aside, you remain disqualified. That's the premise of Samuel Baloch, number one. Number two, Samuel Baloch also says that declaration is not right in your face, saying that you infer from the circumstances of the case. For example, वो कहेंगे कि आपने मिस डिक्लेरेशन की है, इससे इन्फर कर रहे हैं आप ऑनेस्ट नहीं. बिकॉज नो वर्ड इज डायरेक्टली, इस पे तो एविडेंस नहीं ना आप ऑनेस्ट है, आई मीन आप इन्फर कर रहे हैं. दैट्स व्हाट सैमुअल बलोच आल्सो सेज. सो यू कंस्ट्रक्ट इट, यू से कि आपका फॉर्म गलत था, आपका ये गलत था, इससे कंस्ट्रक्ट ये करते हैं कि आप अमीन नहीं हैं. दीज आर द टू प्रेमिसेस ऑन व्हिच सैमुअल बलोच प्रोसीड्स. नाउ वी जस्ट नीड टू अंडरस्टैंड वेदर इट ऑल द फैक्ट दैट द डिस्क्वालिफिकेशन स्टैंड्स कैन कंटिन्यू फॉरएवर, एंड इफ दैट डिस्क्वालिफिकेशन वाज टेकन into a criminal proceedings and he went through age 63 and went through a actual conviction, he comes back, and there are a number of other offenses where he commits even a heinous crime, he comes back. तो बस इसका हमें आप बताइए कि the fact Samuel Baloch goes on the premise that declaration on the civil side done will continue as long as that declaration is set aside.
My lord has properly rephrased Samuel Baloch, but my argument is a bit different from that.
Right.
My argument is any declaration coming from a high court in a constitutional
We
jurisdiction.
understood that's not a declaration, so that's all
not a
those
declaration.
declarations
So
are out.
the only court of plenary jurisdiction
Understood.
is election.
Understood. आगे चले, आगे चले.
Now, the whole argument revolves around whether Article 62 and 63 are inherently same or distinct. If they are inherently same, they can be used interchangeably. Then we can interpret 62(1)(f in view of 63(1)(h).